Well, it's now 12 noon. Good afternoon. My name is Dennis McAndrews, and with me today is our attorney colleague, Rachel Rosenberg of our special education department. Look, we have a good turnout today and looking forward to having a nice chat with regard to transition issues into adulthood. Um, I am actually at our Berwyn office, and behind me is we have a mock courtroom that we offer to mock trial competitions for local schools, and we use it for training purposes internally here. It also gets used as a conference room from time to time, and Rachel is joining us from her remote office, and I will start it off by moving to slide number one. At least I think I will. Um, let's see. There we go. So the first aspect that we're going to talk about is school district transition planning. I often say that transition planning is where the rubber meets the road. Those of you who are a little older may remember that there was a commercial years ago for a tire company, and they were saying how important tires are because it's where the rubber meets the road. Uh, Transition planning can be some of the most critical aspects of moving kids with disabilities into adulthood. In Pennsylvania, it starts at age 14 under the federal law at 16. Uh, but really, the most critical times for transition planning are the last 2 to 3 years of whatever time the child with disabilities is going to be in the special education system. It's just critically important because if done right, it allows the kid to move into community opportunities. And it allows the child to have meaningful opportunities to be with people outside of the school, which is where the child is going to move into adulthood. So let's take a look at what transition services are. And I'm going to make some suggestions about how we can look at transition in the best possible light. Just before I jump into that, a little bit of history. While transition services have for a long time been a required part of IEPs, it wasn't until amendments to IDEA in 1999 and then subsequently those that became effective in 2005 that it really was defined as something that was critical. And what we're looking at now is what is in the act and has been there for the last 20 years. It Before that, it was I is what transition is what I would refer to as the poor stepchild of IEPs. Without exaggeration, when I first started doing this work, transition within IEPs were more often than not the telephone number for the Mental Health Intellectual Disabilities Administration in the county and a suggestion that the family called to get a caseworker. Literally, it was often, more often than not, nothing more than that. Now it is a far more specified, far more goal oriented, far more structured part of an IEP. And so it means a coordinated set of activities for a child with a disability that's designed to be within a results-oriented process, focused on improving the academic and functional achievement of the child. So let's take a look at the words results-oriented and functional achievement. Uh, One of the major suggestions that I have for families of children who are not preparing to go to college, but are preparing, hopefully, to be involved in some sort of post high school employment. Um, but perhaps they're at a modest level and even can't benefit greatly from a vocational program at one of the intermediate unit programs. I always suggest that the family go to a business uh, uh, that they shop at, uh, uh, and ask, if my child has an aide and a job coach, will you let that child come into this workplace and work for 5, 10 hours a week? That is some of the most important uh, parts of transition. To get a child into a workplace, it could be the local supermarket, it could be the local gym, it could be even the local township if there is work that can be done. The concern I have so often is that when transition is mostly or entirely done within the school system, it tends to be shredding, mail delivery among classrooms, and cleaning tables in the cafeteria. Those skills can be taught fairly quickly, and they are not terribly transferable into competitive employment. It needs to be much broader than that, we have, in my experience, we've seen a number of children with various levels of intellectual disability who have done that kind of a out of school program with an aide and with a job coach. The job coach would be itinerant, not constant, but the aide would probably be constant, at least until the child had more independence. But those are the kids that you see at the supermarket who are stocking shelves and bagging and helping people, sometimes on the cash register, depending. But the bottom line is those are the kids that find competitive or largely competitive employment. And those are the kids that are able to live more independently. Now, to be sure, uh, transition is not just for kids who aren't going to go to college. There are plenty of kids who are going to college or a vocational school. And Pennsylvania, by the way, has some very good vocational schools, even residential vocational schools, through the Office of Vocational Rehabilitation, which for those kids should be part of the IEP meetings. They should be invited and they are expected to attend to offer the programs that OVR can offer. But even kids who go to college should be part of transition planning. They should be, they may need organizational skills. They may need some training for how to advocate for themselves with the student services in order to get extra time, a quiet place to take exams, perhaps teacher made notes. That there's a whole, and we'll look at some of those in the college level, but they may need to understand better how to care for their room when they get to a dorm room. So it's very individualized. It's very dependent upon the kid, and that's why I oftentimes emphasize the functional before achievement. So it's not just academics; it's how they function in real life settings. Um, one story I often tell is I remember listening to a psychologist some years ago who was very frustrated by the fact that a kid's OT was, 50 trials a day trying to teach the child how to tie his shoes. And the psychologist said nobody cares in the workplace whether he can tie his shoes or not. Give the kid loafers and teach the kid how to say hello and greet customers when they come through the door. Well, that's far more important than whether the kid can tie shoes. So, occupational therapy isn't just physical manipulation of things, it's teaching kids how to move into community workplaces. So it's a coordinated set of activities. All right. Transition is to be coordinated. It's not just catch as catch can. It's activities that are designed, sorry, um, for those results, and it's based on the individual child's needs. You have to look at the kid's strengths, preferences, interests, and what does it include? It can include instruction. Remember, we talked about teaching a kid how to keep his room, teaching a kid how to greet people at a workplace, community experiences, which is what we've talked about in a workplace, incredibly important. It involves the development of employment and post-school living objectives. You've got to have goals. And transition services have to be based upon assessments that tell you what the kids' interests are, what the kids' needs are, what the kids' strengths are. And then you set goals, because if you don't set high goals, you will never achieve them. If appropriate, the transition plan has to talk about acquiring daily living skills for kids who, um, you know, have to learn better how to dress themselves, their hygiene. It's whatever the assessment shows that the kid needs. Transition services for kids with disabilities, it can be special ed. It can be a related services such as the occupational therapy we talked about. It can be in regular education, depending upon where and the level of need that the child has. Uh, Now, it has to begin not later with the first IEP when the child turns 16 under federal law or younger if determined by the IEP team or state law, which it does in Pennsylvania. And the IEP has to include, here are the things that transition services have to include in the IEP. Measurable post-secondary goals based on age-appropriate transition assessments. That's just what we said. So you need to set specific and measurable goals as to where we want this kid to be at the end of the school year with regard to the transition services. So for a kid who maybe is working in a supermarket, I just use that as an example, that he will be able to independently stock shelves with particular types of products, or that he will be able to accompany someone to their car with a cart and load the groceries into the cart into the car, or that he'll be able to do that with prompts 90% of the time, or be able to do it independently 90% of the time. So you want those measurable goals. And so second, the transition services have to be identified. It could be courses of study. It can be supports such as the aid. It can be the job coach, those things that are needed to assist the child in reaching the goals. So at this point, I think, Rachel, don't I turn it over to you?
Yes, you do. So
Okay, you
I'm
go.
going to talk about the best way to optimize the IEP meetings and transition goals so that you can ensure that the student is best prepared for that transition into adulthood. Dennis, if you could go to the next slide. So if a student is eligible for services through OVR, and as Dennis mentioned, that is the Office for Vocational Rehabilitation, any student with a disability who might need vocational counseling and guidance, as well as assistance in preparing for obtaining or maintaining competitive employment, be eligible through OVR. And if they are eligible through OVR, they should be invited to the IEP meeting, and they're actually required to attend the IEP meeting by the Workforce Innovation and Opportunity Act. At the IEP meetings, you should incorporate goals from ISPs, that's individual service plans, and IPEs, that's individualized plan for employment, into the IEP's transition goals, including the pre-employment transition services. Could you go to the next slide?
I do that right? Let's see.
I think there's a slide. There we go.
There we go.
Transition goals. All right. So in terms of creating these transition goals in the IEP meetings, these shouldn't restate different academic skills that the student has been working on throughout his time in school. For example, increased reading skills. These goals should focus more on job-focused areas for improvement, like creating a resume, completing a job application independently, and being familiar with EEOC complaint forms, which is the Equal Employment Opportunity Commission. You should also include goals for creating an academic adjustment request, identifying campus supports for students with disabilities, and being familiar with OCR complaint forms, or Office for Civil Rights.
And, not only do you not want to restate academic skills, you want goals to be measurable. Especially early in my career, I would see goals like increase reading skills. And my answer was always, I hope I increase my reading skills. I mean, that is not a measurable goal. And reading has many components of it. It has decoding, it has fluency, it's got vocabulary, it's got comprehension. You need to identify where the need is and then say with specificity where that child is expected to be at the end of the year, so that you can identify whether the form of instruction needs to be modified. And that's one of the many reasons it needs to be specific. All right, it's back to me, I believe, Rachel. Is that correct?
That is correct.
I let Rachel tell me what I need to be doing here, so that's good. All right, we're going to move into the post-secondary education and disability rights part of the talk today. So we're talking here about kids who are in post-secondary programs. It can be a college, it can be a community college, it could be a vocational school. So the kids with disabilities who meet the standards for admission to whatever post-secondary education program we're discussing can receive academic modifications, aids and services. And the goal here is to ensure equal opportunity to participate successfully in the program. Technically, they're called academic adjustments, not accommodations, but either term is fine. What we're talking about, and kids in these post-secondary programs do not have IEPs, but they do have some sort of a plan. There's supposed to be a written plan of some sort to identify what adjustments are appropriate. And again, they have to be qualified for admission. They have to be capable of doing the work and succeeding with the modifications, aids, adjustments. Now, what are appropriate adjustments? Again, that has to be based on disability and individual needs. We're talking here about the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, which are essentially mirror images of each other. 504 has been around since 1973, and that's for everyone that gets federal funding, that they're not to discriminate on the basis of disability. The ADA came into effect in 1991, and it's the same, but it's broader than just companies or organizations that receive federal funding. It's pretty much any public accommodation or public entity. So almost every school is going to be required to follow the ADA, and that's the broader of the two, but their actual requirements are very similar. So bottom line, you have to look at disability and individual needs. The adjustments can be auxiliary aid services, modifications to academic requirements. And again, the goal here is to ensure equal educational opportunity. In providing an academic adjustment, schools don't have to reduce or substantially modify the essential requirements of what they do, whether that's admission, whether that's testing, whether it's what kind of homework has to be provided. They don't have to make adjustments that would fundamentally alter their educational program. They don't have to make adjustments that would be an undue financial or administrative burden. And examples of these areas of adjustment that they don't have to provide. They don't have to provide a personal attendant. They don't have to provide somebody to walk people through campus and sit with them in class and help them. They don't have to provide individually prescribed devices like hearing aids or wheelchairs. They don't typically have to provide readers for personal use or study, but I would not say that that's a never. Again, it depends on the kid. If a kid is blind, but is very capable, then that might be a reader might be something that would be required. But they don't have to provide, devices. They don't have to provide tutoring, typing, but they may have to provide a generalized program for of like a math lab that is accessible to kids, or a reading or writing lab. They may have to provide for a specific kid voice to text, although frankly, almost every computer has it now anyway. It's about the only way I survive as a lawyer these days. Um, but what are some adjustments that are made college, community college, vocational school? Priority registration. I remember, when I went to college, there'd be some schools would just let everybody try to register at the same time. There would be a mad rush to the registrar and long lines to try to get the courses that you wanted or needed, or in some cases, not me, the easiest courses. There would be people trying to get the easiest courses. I never heard of such a thing. But you may give priority registration for kids with disabilities so that you could be sure that they would get the courses that were appropriate for them, so that they wouldn't get, X'd out of a beginning statistics course for people who will never use statistics and get thrown into a statistics for statisticians to try to make a requirement for a degree. Reduce a course load. While at a college, a full load might be 12 credits, maybe you move it down to 9 to allow the student to have extra time to work on those courses. May substitute one course for another. Let's say all students are expected to take a foreign language for two courses, a full year of a foreign language. Well, there are some kids, especially some kids with dyslexia or a language issue. You may as well put flaming bamboo shoots under their nails to ask them to learn a foreign language. I mean, it's just, one, they'll never use it. Two, their skill set does not lend itself to it. So you let them take 2 extra English courses. Now, if they're in the School of Foreign Service, that might be something different. They do have to have a language. So, maybe they're not qualified then for the School of Foreign Service. These are the kinds of individual decisions have to make. Provide note takers. The school may have students in particular classes who are paid a little something to take notes, or the teacher may be asked to provide notes to the student with disabilities. Allow the student to record lectures. So many college teachers don't want their lectures recorded because they want to say whatever they want to say. Well, too bad. You may have to tone down your opinions a little bit if it's going to be recorded. But it's just an accommodation that is reasonable for a kid who needs that. It could be a sign language interpreter. Extra time for testing and a quiet room for testing, very, very common. And by the way, I taught at the college level for 30 years. And when I started, which would have been 1978, these things were pretty much unknown, even though the Section 504 of the Rehabilitation Act was in play. You just didn't have kids that would be taking tests in quiet rooms with extra time. By the time I concluded my college teaching career about 10 years ago, every course I had, there were any number of students who would be taking their exam, and they would, um, they would have the student services office take a look at their evaluations, their if they had passed IEPs or service plans, and come to a conclusion as to what the child needed in terms of an academic adjustment. Uh, Persons with disabilities have a right to physical access to the programs. If a class meets at on the second floor and it's a building that doesn't have an elevator, well, the college may very well have to move that classroom to a first floor, and all those facilities should have accessibility at least to the first floor, so that the students have access to it. Sections of old buildings may need to be renovated. And new buildings always have to be constructed so that individuals with disabilities who use wheelchairs can enter and navigate. The websites have to be accessible to people with um, disabilities that prevent them from accessing it. What do you do if there's discrimination? Every school has to have a 504 and ADA coordinator. Sometimes it's called a disability services coordinator. Sometimes it's a student services coordinator. Um, Oftentimes that role is coupled with Title IX for sex discrimination or sexual misbehavior. But that's who you go to. That's who coordinates the school's compliance with 504, Title II of the ADA, sometimes Title IX. The school has to have grievance procedures for steps to ensure that the students can raise their concerns and promptly resolve those complaints. And usually the student handbooks describe the steps of the grievance procedure. You can always go to the Office of Civil Rights, and here you see how to file a complaint. That is not a rapid response team. If you file one with the Office of Civil Rights, or in Pennsylvania, you could file it with the Pennsylvania Human Relations Commission. Neither of those organizations are, you'll probably be in the workplace by the time they get around to deciding it, unless you're lucky. Uh, but it is an option, and even the statement that you're going to file that complaint may get the attention of the school, because they don't like the Office of Civil Rights coming in and rummaging around their files to see if they've been discriminating against kids with disabilities. All right, Rachel, I believe it's back to you.
All right. So now I'm going to talk about the different protections that students have leaving school in the workplace. So as Dennis mentioned, the ADA, or the Americans with Disability Act, is a federal civil rights law that protects against discrimination based on disability. And just like it applies in school, as Dennis just talked about, it also applies in the workplace. And that includes private employers as well. They're also required to abide by the ADA. So job discrimination against people with disabilities is illegal if it's practiced by, like I just said, private employers, state and local governments, employment agencies, labor organizations, and labor management committees. Could you advance to the next slide, please? So how do you know if you are protected by the ADA? If you have a disability and are qualified to do a job, the ADA protects you from job discrimination on the basis of your disability. Under the ADA, you have a disability if you have a physical or mental impairment that substantially limits a major life activity. The ADA also protects you if you have a history of such a disability, or if an employer believes that you have such a disability, even if you don't. So what's important about this is that the person still needs to be qualified to do the job with the disability. And then as long as they're qualified to do everything in the job description with a reasonable accommodation, which I'll touch on in a moment, then you're protected from job discrimination on the basis of your disability. If you are applying for a job, an employer cannot ask if you are disabled or ask about the nature or severity of your disability. An employer can ask if you can perform the duties of a job with or without a reasonable accommodation. An employer can also ask you to describe or to demonstrate how, with or without reasonable accommodation, you'll perform the duties of the job. Can you go to the next slide?
There we go. Oh, wrong one.
I think you went
Uh,
backwards. Yeah,
Sorry.
that's okay.
Okay. Staff.
So now one more. There we go. So a common
Thank you.
question that people ask are if you have to tell the employer during the application process, during the interview, that you might need an accommodation to perform the job. And no, you do not. The ADA does not, sorry, can you?
Yes. Oh my gosh, I am so sorry.
No, it's okay. It'd be better if we could both click through the slides at the same time, but technology, not there yet, I guess. So the ADA does not require that an applicant inform an employer about the need for a reasonable accommodation at any particular time. So this information need not be volunteered on an application form or in an interview. The time to ask for that you need to tell an employer about a reasonable accommodation you might need is when you need that accommodation. So when to request the accommodation. You can request an accommodation at any time during the application process or once you're already employed. In general, an employee should request an accommodation when there is a workplace barrier that, due to a disability, prevents the employee from competing for a job, performing a job, or gaining equal access to a benefit of employment like an employee lunchroom or employee parking.
Rachel, I'm going to go back a couple because I'm wondering if did I miss that one for you, or were you able to cover that?
I covered that.
Okay.
Okay, so does an employee need to tell the employer about the disability? So under the ADA, employers are only required to provide accommodations for employees who are experiencing workplace problems because of a disability. Therefore, unless the employee lets the employer know of the disability, the employer is not obligated to consider accommodations under the ADA. So as we already discussed, if you have a disability, you're not required to tell the employer. However, if you need a reasonable accommodation to do the job, you need to tell the employer that you need that reasonable accommodation because of a disability so that the employer can provide it. How much medical information must be provided to the employer when requesting a reasonable accommodation on the basis of a disability? Employers do have the right to request sufficient medical information when an employee requests an accommodation, and if the employee does not provide it, the employer can deny the accommodation request. So what are some examples of accommodations that can be requested from employers? Under the ADA, employers are required to provide reasonable accommodations for employees with disabilities. So for instance, this could include a ramp for an employee who has a wheelchair. Here are some other examples. Making existing facilities accessible, like something like a ramp. Part-time or modified work schedules, if somebody requires that kind of a schedule in order to perform the duties of the job. Acquiring or modifying equipment to allow somebody to do a job. Providing qualified readers or interpreters, or reassignment to a vacant position. So the following are not considered forms of reasonable accommodations. Removing or eliminating an essential function from a job. So as I said, it's really vital that the employee is able to perform all of the duties and essential functions of the job. If they can't perform an essential function of the job, then that might not be the best job for him or her. So removing an essential function from the job would not be a reasonable accommodation. And also lowering production standards wouldn't be a reasonable accommodation. Neither would be providing personal use items such as a prosthetic limb a wheelchair, eyeglasses, hearing aids, or similar devices if they're also needed off of the job. Undue hardship. So an employer would need to say that in order for an employer to say that they don't need to provide what you consider to be a reasonable accommodation, they need to say that they don't need to provide it because it would cause an undue hardship on the employer. So no change or modification is required if it would cause an undue hardship on the employer. So undue hardship means a significant difficulty or expense and focuses on the resources and circumstances of the particular employer in relationship to the cost or difficulty of providing a specific accommodation. Undue hardship refers not only to financial difficulty, but to accommodations that would fundamentally alter the nature or operation of the business. So some examples of an undue hardship would be requesting that the employer hire additional employees to help perform an individual's job. Another undue hardship would be asking an employer to remove a lifting requirement from a role that specifically requires the ability to frequently move boxes weighing 50 pounds or more as a primary responsibility. So, asking them to do something that changes the essential duties of the job would be an undue hardship.
All right, it's back to me.
Back to you,
Let's
Dennis.
see if I can goof up the movement of the slides for me, is just like I did to poor Rachel there. Okay, just some additional things to be thinking about. At age 18, a child with a disability can be eligible for supplemental security income on his or her own uh, um, resources and assets and income. So in most cases, kids don't have resources in excess of the $2,000 limit. They don't have income that's great enough. Uh, uh, so it's important to explore SSI at age 18. And if you get SSI, if the child has a disability which would substantially limit substantial gainful employment, uh, the child would likely be eligible for SSI. And once you get SSI at 18, you can get a check of up to about $940 a month. And by the way, if the child is still living at home, you should be charging the child room and board of somewhere around $450 a month. Because if you don't charge rent, the SSI check will be reduced by about a third because you are providing what's known as in-kind support and maintenance. So apply for SSI and have some sort of a written agreement. It can be literally a paragraph saying you will be providing room. Actually, I wouldn't even nowadays put board because food is excluded from in-kind support and maintenance as of September. But indicate that you're providing housing for the child at a rate of, I would say, $425 a month. And the parent can keep that. The parent could put it in an ABLE account, ABLE account through the Pennsylvania Treasury Department, which you can put $18,000 a year into an ABLE account, and it can be used for any disability related purpose. And that can include housing if the child goes away to school. So you should be investigating an SSI application. If you get $1 of SSI, you automatically get medical assistance, which can be very valuable insurance, even if you have private insurance for the child, because it can pay deductibles and co-pays, and is valuable on many levels for almost any kid. So look into an SSI, look into an ABLE account, and medical assistance will automatically come if you get SSI. For kids with mental health, intellectual disabilities, you want to establish a relationship. I'd say no later than your 18th birthday. You can do it even before that. So that you get casework, you can determine eligibility for services. if there's crisis management issues, respite care that might be necessary for, more significantly involved kids. Fill out the PUNS form. I think that's being kind of eased out, transitioned out, and another form that they're going to be using. But if you talk about the PUNS form, which is helping determine what sort of need for services they're going to be, especially after the child leaves the educational system. There are Medicaid waivers that provide either residential programs for kids with very serious disabilities. There's also person or family directed community support programs where the parents are provided funds to access additional services for kids. Most of those kick in after the child's out of school, but you can't start too early. You want to get on the list to obtain those services. Register with OVR. They can provide diagnostic services, vocational evaluation, counseling, training, and they even have, residential school, restorative services, physical therapy, occupational therapy, assistive technology, which can be very important for some kids in the workplace. So you want to connect with OVR to discuss eligibility within that system. Going to go to the next, before I turn it over to Rachel, who's going to talk about the next set of slides. One thing that I think is very important to consider, actually, I'm going to go backwards just so that we know we're talking about an additional issue. Seriously consider getting a power of attorney for your child once the child reaches 18, because once the child reaches 18, they're no longer a minor in the eyes of the law. They can make their own decisions. And if they go away to school, unless you have a power of attorney and there's some mental health crisis, financial crisis, academic crisis, people won't talk with you. It doesn't matter that you're paying the bills. I'm sure many of you, and I certainly have, heard the horror stories of people, uh, of kids who go away to college, and the parents learn what they think is the senior year that no, the kid's actually a first semester junior, because they've been dropping courses. They haven't seen the report cards because they're sent to the kid. So, but if you have a power of attorney, and so many kids freshman year show up and have some sort of mental health issue. They go to the counseling center. You may get a call from a roommate that, somebody went to the hospital or is acting very strange, and you need to be able to talk to the counseling center. So I think it's very important to have the kid give the parents a power of attorney, because it allows the parent to have discussions with school officials or medical officials, which might otherwise be prevented. All right, back to you, Miss Rachel.
All right, so I'll just talk about a couple of mental health services that might be helpful for students transitioning into adulthood in approximate order of level of restrictiveness, meaning, going from something like outpatient to ranging all the way to something where they're completely inpatient. Can you hit the next slide? So the least restrictive would be outpatient therapy. Moving from there would be a school-based mental health services that the school could provide to help students with their mental health. Next would be behavioral health rehabilitation services. Then the next restrictive level of mental health services would be a partial hospitalization service, where a student or somebody in the employment world could be partially hospitalized receiving services, not full-time, but for part of the time. Do the next slide. And then the most restrictive mental health services are family-based mental health services, community residential rehabilitation services, CRRs. mental health residential treatment facility, where they are in a residential full-time treatment facility, and then inpatient psychiatric hospitalization.
Uh, as the families investigate post-high school programs, there's some really excellent resources. Um, and these are some websites that you see. There is a whole cottage industry now of colleges that have within their college a program for students with special needs, the students who frankly would not qualify for their typical college program, but they have a a group, a cadre of students that go through a program together. They take courses. Some of them may be actual college courses, others may be life skills courses. But my point is that there are a lot of programs now for kids with disabilities, not only higher achieving kids with disabilities who, go through the typical college scenario, but with some supports. But they're also for kids who would not otherwise go to college, kids with intellectual disabilities, kids with autism. And they have separate programs within the college for those kids, or there are schools themselves that just serve these kids. And oftentimes they live in dorms, sometimes generally with more support than a typical college student would have. But these are some websites that do provide um, some really excellent options for families to be able to consider. Uh, Here you see our various locations, and we hope that this has been helpful. I would encourage you to look at our website. We recently had an article, for example, about powers of attorney for kids going to college. Advanced medical directive is often a good idea as well. But our website has dozens and dozens of articles on these issues and many other issues with regard to students with disabilities, about estate planning for kids with disabilities, and also for Title IX for people who are the victim of sexual discrimination or who have been accused of it and need to defend themselves. So we thank you all for being part of this program today. And we hope the rest of your day is a good one. Rachel, I want to thank you for collaborating with me. It's always a pleasure to work with you, and
Thank
Rachel's a
you.
great attorney. So thank you.
Thank you.
So that concludes our program for today. Again, we hope the rest of your day is excellent. And if we can help, please check out our website. We have a contact us on our website where you can reach out and we can provide additional information or legal assistance if necessary. So thank you. Have a great day. And we hope to connect with all of you at some point. Take care. Goodbye now.
Thanks so much.